At the close of an ordinary day on the docket in Greenwood County Magistrate Court in Eureka, Kansas, the cameras caught a moment that was anything but routine. Judge Phyllis Webster and County Attorney Jill Gillette were going over the names of people accused of missing their court dates when the judge spotted a problem that changed everything. A procedural breakdown meant she may not have had the legal power to act at all, and her remarks suggested the mistake may have started inside the county attorney's office. What happened next quickly turned a simple calendar issue into a confrontation that could have carried serious professional consequences.
Tanya Sanchez.
We already did Sanchez. We have a Tiana Richardson and a Dustin Newport I still have.
Well, hold on. That's not what I'm showing. What do you have, Missy?
I have Alfonso Caldwell and Tiana Richardson. That Newport bonded out, or no, well, he bonded on ours, and then Lyon County come and got him before.
I noticed, okay, he was taken off the docket. And what did I do? Mix up Tanya Richardson and Sanchez?
Mm-hmm.
And no one mentioned that I was using the wrong name?
You were using the right name.
Well, and these are my couple that I don't have anything filed to show that they have to be in court. I don't have a summons. I don't have a uniform notice to appear issued by the officer in the ticket.
Judge, the girls filed the ticket earlier today.
Okay, let me see if it's, maybe I just need to double check. Mr. Caldwell.
Mm-hmm. Tickets were issued January 23rd, 25 at 20:59 hours. But
Okay,
today,
well, let me make sure they made it to the file because I'm not seeing that. I don't see that, Ms. Gillette, and until I have filed verification that they had noticed this hearing. I'm not finding that. You're sure they filed them?
Arlene was the one who did it for us.
No, Missy, do you have that where you can look at it? Because I am not seeing it filed. Maybe I need to. No, I think I've already refreshed to see if they've been added. What was that, Missy?
I said they're not showing up in the case yet.
I don't know if upstairs hasn't approved them or what's going on.
I can check.
Would you check? We'll take just a real quick recess because I don't have anything in the file to show they have notice of the hearing, so I can't take any action for their failure to appear without it.
Judge Webster's position was straightforward and legally significant. Without something in the file proving these defendants were actually notified to appear, she could not punish them for failing to show up. In situations like this, judges often can issue bench warrants when someone knowingly skips court. Kansas law, including Section 194739, gives courts that authority in certain county code cases, allowing contempt findings and arrest warrants when a defendant fails to appear after being served notice. And that last part is the key. Whatever these defendants were accused of, none of it matters unless the court can first show they were properly told to be there. Without proof of notice, the entire foundation collapses. That is exactly why Judge Webster refused to move forward without the paperwork.
Arlene's going to bring the unfiled copy upstairs, Your Honor, but they were submitted this morning by Jessica.
I need the originals. You're thinking the originals are on file somewhere or waiting to be filed? See what Missy finds. Maybe they'll find the originals at the clerk's.
What, Judge? I'm sorry, I'm back now.
Well, she said they'll bring up, if I understood Ms. Gillette right, they're bringing up copies, but where are the originals?
I think I actually have a copy because I was asking them today about it, so
Well, I
can print you off the copies that I got sent.
copies. I need original documentation that these people had notice of this hearing, either in the form of a returned summons or a citation. And I don't have anything to show that they know about this hearing today.
Your Honor, the citations, we get a Xerox of them. We don't get the originals. The originals normally stay either in the file with the sheriff's office now, or they go straight upstairs. But this had to be long formed because it's marijuana. And so...
Well, even with the long form, I would accept You don't have the originals, Arlene? You have copies? Have those been filed with the clerk?
Yes.
They have been filed. They didn't make it into their file. Do you know why?
Well, because that's the clerks.
Well, Missy, did you check with the clerks?
Yes, I just checked with them and they do not have them. They're not in the queue to approve.
I know they're not in the queue. I looked through the queue. Oh, unless you mean their queue.
Yeah,
Well,
they're,
what I'm going to do, now I'm looking at copies of tickets, and I've seen enough tickets over the years to know these are tickets, and they do appear to be signed by the signature I know as Blake Fisher's, although I'm not an expert in handwriting. But I am not comfortable issuing any kind of failure to appear warrants if there's no documentation in the file. These are just handed to me, but once they are filed, then I would not hesitate to issue warrants for their failures to appear. So I'm going to set these two cases over till next Tuesday. By then, I'm sure that we'll figure out why those haven't been filed. And then if they're not here at that date and time, we'll issue warrants. But they'll have to be given notice of the new date and time. And it looks like they're out of Wichita, Kansas. Yes, so
If I have to issue new summonses, then it's going to be more than a week because I have to issue them, send them to Wichita, and have them served on them. They have their notices to appear, complaints.
all right, I'll tell you what. I
I
don't.
don't even get the original anymore.
Just file the copies, whatever, but they have to be filed, Miss Gillette. I have nothing that gives me legal authority to issue failure to appear warrants. I have in the file, and I'm looking at it, a complaint, a probable cause affidavit, a notice that you're going to rely on KBI reports, and that's it. There is nothing in the file to show legally that they have notice of this hearing. So I don't know where the tickets are. I don't know why they're not filed. I understand that someone in your office said they gave them to the clerk. I understand the clerk to say they don't have them. I don't know where they are, but I do not have them, so I cannot issue any kind of warrant for failure to appear. In fact, if you find them and get them in there even today, we can deal with it today rather than trying to issue summonses. Get me something I can legally use. Otherwise,
I'll call Sheriff Samuels and ask him if he can bring the originals out of his file.
I'm not telling you have to do the originals. I'm just telling you, Miss Gillette, I cannot legally issue a warrant. And you know that. You know I have to have verification before I issue a warrant.
And we emailed them to your staff who has them this morning. They were sent to
My secretary is not the clerk of the district court. My secretary is not the custodian for that. They have to be
brought it
filed.
up to you. I'm not going to argue with you.
Well, you better not.
We'll just take it up later.
Miss Gillette, who is the judge here? I am not going to accept your behavior. You're putting me in a position where I'm going to have to find you in contempt of court if you're going to act like this.
I don't have the original, Judge. I can't get it to you. We filed them this morning. That's all I can tell you.
Miss Gillette, you are not listening to me, and you're being contemptuous.
The state has contempt immunity. We already briefed this. If you would like us to get them filed again, we will
You
file.
have contempt immunity? Do you have ethical immunity that you can talk to a judge any way you want and have no repercussions? Is this what you're saying?
Then the clash escalated. Gillette argued that prosecutors are immune from contempt, but Judge Webster immediately turned to a different issue just as important. Even if someone claims legal protection, that does not erase an attorney's duty to behave professionally in court. The law does give prosecutors broad protection in some situations. In the 1976 Supreme Court case, Imbler v. Patchman, the court held that prosecutors acting within the scope of pursuing criminal cases are absolutely immune from civil suits for damages. The reasoning was that the justice system depends on prosecutors being able to do their jobs aggressively and without fear of constant personal lawsuits. But that is a very different question from whether a judge can respond to misconduct happening right in the courtroom. Kansas statutes on direct contempt give judges authority to punish contempt committed in their presence, and nothing in that language carves out a special exception for prosecutors. Courts have recognized for well over a century that attorneys can be held in contempt for disrespectful conduct before the bench. In the 1877 Kansas case in Ray Pryor, the court made it clear that lawyers, as officers of the court, have a heightened duty to preserve the dignity of the tribunal. They can challenge arguments, criticize evidence, and fight hard for their side, but they still must do it with courtesy and respect. Now, to be fair, there does not appear to be clear case law here confirming Gillette's claim that prosecutors are immune from contempt, though she did say the issue had already been briefed, which suggests she believed she had at least some legal basis for saying it. Even so, that would not end the matter. Lawyers are also governed by professional conduct rules, and those rules can carry consequences of their own. Under Kansas Rule 3.5d, an attorney may not engage in undignified or discourteous conduct that degrades a tribunal. So even if contempt were somehow off the table, courtroom behavior like this could still raise real ethical concerns.
Judge, I will find the originals, whoever has them, and we'll see if we can get them to you. We will get them filed.
And we will finish this later, Miss Gillette. At this time, Missy, it looks like Miss Gillette has decided to remove herself from the hearing. As I said, this matter is not over and it will not be tolerated. But for now, we will be in recess.
It is not clear whether Gillette was ever formally disciplined, and she has since appeared in court alongside Judge Webster without any visible hostility. But the bigger lesson from this exchange is hard to miss. Prosecutors may have certain legal protections, but those protections are not a license to ignore procedure, and they are certainly not a shield against every consequence that comes with bad judgment in open court. The rules still matter, and so does the way those rules are enforced. Judge Webster deserves real credit here. Even though she seemed to believe the information being relayed was probably legitimate, she refused to sign off on warrants unless the law actually allowed her to do it. She insisted the state meet the same procedural standard any ordinary citizen would be held to, and that kind of restraint matters. At the same time, one heated moment should not be treated as a complete verdict on Gillette's character or ability as a county attorney. Administrative mistakes are maddening, especially in high-pressure jobs, and most people know what it feels like to hit a breaking point on a bad day. That does not excuse the outburst, but it does put it in human terms. If there is another courtroom exchange or legal showdown you want covered, drop it below. Thanks for watching, and if you found this breakdown worthwhile, share it so more people can better understand how the justice system really works.